So my name's Corinne. I'm one of the solicitors in the employment department at Dickinson Solicitors. I'm here today to talk to you about an introduction to employment law. We've only got an hour, so it really is going to be a really brief introduction, whistle-stop tour. Employment law is it's a really wide-ranging area. It's not just your unfair dismissal and your redundancy. You've got whistleblowing, discrimination, family-friendly rights, all sorts of things. So we're just literally going to touch on some of them today. If you have got any questions, if they're burning questions, if you want to shout out, I'll try my best to answer them. If not, my contact details are on the slides. You can drop me an email, or I'll stay for a little bit afterwards, probably get a cup of tea before I go, so you can try and grab me then. So why is it important to know about employment law? Well, it's important for employers to know about employees' rights and their responsibilities, not only because if something goes wrong in the employment relationship, the impact upon an employee can be really profound. You know, it's their job, it's their life. The impact can be massive financially, but also psychologically. So we're seeing loads of claims recently with mental health issues where the way that an employer has treated someone has really affected their life, and that can have a massive impact on the way that tribunals will award compensation and things like that. So I think it's a really interesting area of law, more so than your regular contractual issues between two companies and things, because it's really important to a lot of people. The compensation that can be awarded if things do go wrong in a claim. Shall I just hold it? I'll just hold it. The compensation can be unlimited in some circumstances. So a lot of employers don't want a claim to be made, not only because it's bad for their reputation, it's also potentially going to cost them a lot of money. Millions of pounds have been awarded. Depends on the type of claim, but it can be a lot. And then, like I said, it's not good for an employer's reputation if they go to tribunal. The matter is then in the public domain, so the press can come into the hearing. It can be in the papers, and that's also not good for staff morale. If you know that your colleague has been subjected to whatever sort of treatment, you want your staff to be trusting and a strong team. So that's why it's important for employers to know exactly what they're responsible for and what the employee's rights are. So we'll go through them. I've lost my clicker. These are some of the things that we're going to go through today. Contractual rights, so rights that employees get from their employment contract. The right not to be subjected to unlawful discrimination. Reasonable adjustments for disabled employees, family-friendly rights, and the right not to be unfairly dismissed. So with a contract of employment, there's not actually any legal obligation to have a written contract. Most people do, but an employment contract can be written or it can be verbal, can just be there by conduct. If you turn up and someone pays you every day that you turn up, then that is a contract. There is some law that says you have to be provided with certain terms, so you pay, notice periods, holiday pay, those sort of things are supposed to be given to you within 2 months of starting your job. Most employers will hand out a contract or give details in a handbook of holiday pay, sick pay, that sort of thing. There are implied terms in most all employment contracts will have the implied term of trust and confidence and fidelity, and a few other implied terms, and they just exist because it's an employment relationship. The duty of fidelity, you're probably aware of, it's just basically not to compete against your employer, maintain your duty of confidentiality, not to disrupt the business. And the duty of trust and confidence is called a mutual duty because it's supposed to be between both the employer and the employee. And that would be, that's a very common cause of employment tribunal claims where the employee will say the employer has breached the duty of mutual trust and confidence. And that would be things where if you made a grievance, for example, and the employer just ignored it, or there was a manager maybe spoke to you in a way in front of colleagues in a way that you felt was not very nice. So if those terms are breached, then it can be a breach of contract, which can lead to disciplinary action if it's the employee that breached it, or potentially a claim for unfair dismissal if it's the employer that's breached those terms. Other sort of implied terms are a duty to obey reasonable orders. So if your boss tells you to do something, provided it's reasonable, then unfortunately you've got to do it within reason. And you've got to exercise reasonable care and skill. So if an employer thinks that an employee isn't abiding with those terms, then it can usually is something that would then lead to some form of disciplinary action. Discrimination is probably something that takes up most of my time. So the Equality Act 2010 is concerned with protecting employees against discrimination and harassment. I say employees, but actually it covers a wider range of people. It includes service users and workers and all sorts of people. But it is related to these protected characteristics which are on the slide there. So it's protecting people against discrimination and harassment related to these characteristics. So age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex or sexual orientation. So if someone feels that they've been discriminated against or harassed in relation to any of those characteristics, then they potentially can bring a claim for discrimination. There's various types of discrimination that we'll skip through on the next slide. But one of the main fears of employers with discrimination claims is that the compensation can be unlimited. With unfair dismissal, for example, there's a cap on how much money people can get, and employers sometimes think, oh, well, they're only going to get this much money, we'll risk it. With discrimination, it has been millions of pounds in the past. That's usually with higher earners who coming towards the end of their careers. But it's definitely something that employers want to avoid, not only for the financial reasons, but also for the impact on the employees and the workforce generally. There's no qualifying period of service, which means that you could bring a claim on day one of your employment. With unfair dismissal, you have to have worked for someone for 2 years. Whereas discrimination, and it's the same for whistleblowing, it doesn't matter how long you've worked there, you've got that protection immediately. So the types of discrimination are direct discrimination, which is the obvious one, where you treat someone less favourably because of a protected characteristic. So, for example, this covers employees and also job applicants. So say if someone applied for a job and they weren't awarded the job and they felt that it was because they were a woman or because they were gay or something like that, they could bring a claim for direct discrimination. And it also covers people, even if you thought it was because someone thought you were gay but you weren't gay, you could still bring a claim for discrimination because it's perception. So it's perceptive and it's also associative. So if you hang around with a group of gay people and someone doesn't like the fact that you're with them, or trade union isn't one that we get, if you hang around with, if you're a member of a trade union and you feel like you're being treated differently because of that, then that could be direct discrimination. Even if you don't actually have that characteristic, you can still bring a claim for it. Indirect discrimination is a little trickier, and it's essentially where an employer has a rule, or it's called, the legislation refers to it as a provision, a criterion, or a practice. So a rule or a policy or something that the employer applies to everyone. So A classic example is a requirement for all staff to work part-time. So that would be applied to everyone. But it potentially is indirectly discriminatory if it affects a particular group of people. So in the past, there's been claims where women have said, this policy that everyone has to work full-time, that indirectly affects women more than men, because women tend to have more childcare responsibilities and tend to want to work part-time or need to work part-time. So if a woman felt like she had been disadvantaged by that sort of policy, she could bring an indirect discrimination claim. She'd have to show that there was a policy in place that affected all women in the workplace and also affected her personally. Now, indirect discrimination, slightly different to direct in that if a tribunal found that you had discriminated someone in that way with some sort of policy, then the employer can objectively justify it. So it says on the slides that it's a proportionate means of achieving a legitimate aim, so that's known as objective justification. And it just means that the employer would need to show that they had a legitimate aim, so some sort of real business need that they were trying to protect, and that it was proportionate, so there was no other way of achieving that. Some examples of a legitimate aim are in, say, an age discrimination situation where someone might feel like they're being encouraged to retire, so age discrimination to older people, or younger people might feel like they're not taken on because they didn't have sufficient experience, which is only because they're young. And in these situations, employers have argued that their legitimate aim is either like promoting experience, rewarding experience, so keeping older people in the business, or promoting access to employment for younger people. So if older people feel like they're being encouraged out or they're not being given promotions, it's because the employer wants to bring in new people into the business, younger people. And an employment tribunal won't really look too far into those reasons, provided the employer can show that there is some sort of business need there. And then the tribunal tends not to concern itself with the business aspects of employers' decisions. They just want to see that they've thought about it and there is a genuine need there. So, yeah, with these indirect discrimination, it's if the employer will always say, oh, it's not discrimination, and if it is, it's justified. And so the tribunal would just be balancing the interests of the employer and the business needs with the personal interests of the employee and the effect upon them. And as with everything in law, it just entirely depends on the circumstances, and one judge will go one way and one judge might go another way. The next one is harassment. Now there's harassment under the Equality Act and there's harassment under the Protection from Harassment Act. So I'm talking about harassment under the Equality Act. So this is harassment related to one of the protected characteristics, so age or sex. There is another form of harassment which can just be harassment, like stalking, that sort of thing that you will have seen in the news. Harassment under the Equality Act is unwanted conduct relating to a relevant protected characteristic with the purpose or effect, which means even if someone doesn't intend for it to have a bad outcome, it's the effect that it can have on someone. So there's been a few cases where people say, oh, it was just banter, it was just a joke. But one person might think it's a joke, another person might really be intimidated or affected by. So the tribunal will look at how it has affected that individual, but it is within reason. So I think it says there, it goes to the person's perception and whether it is reasonable for the conduct to have that effect. So although that person might feel that way, the tribunal will look at whether it was reasonable for that person to feel that way. But the purpose of effect is to either violate their dignity or create an intimidating, hostile, degrading, humiliating, or offensive environment. So it could be that someone is subjected to harassment because they are old, woman, gay. It could be that someone is making, say, racist jokes or talking about people in a degrading way, and someone else hears that or is in the room and they feel that they have been intimidated or basically they're offended, that's the word I was looking for. They're offended by what they've heard. So someone could bring a claim for harassment in those circumstances. I've not come across too many harassment claims. A lot of issues that come up in the workplace are bullying and harassment. That's a claim that's a term that's banded around a lot, but a lot of the times it's bullying, but it's not harassment because of a protected characteristic. It's just people in the workplace falling out and feeling like they're being harassed maybe by a boss who's given them too much work, and they'll come to us and they say, oh, I've been bullied and harassed, but sometimes it's just because there's a personality clash and it's not necessarily linked to one of those protected characteristics. In those circumstances, it would be a case of raising a grievance and dealing with it just under that duty of trust and confidence rather than an Equality Act issue. The final one on the slide is victimisation, and this is one of the rarer ones that I have dealt with, and if an employee is subjected to a detriment after they have maybe threatened to bring a claim or they have brought a claim, or if they've given evidence in a tribunal hearing, it's got to be related to an Equality Act issue. But if someone gave evidence in a tribunal hearing that was to do with discrimination, and then they went for a promotion or they went to go for a new job and they felt that they weren't getting that promotion or the job because of what they'd done in the past that related to an Equality Act claim, then they could bring a claim for victimisation. And it includes former employees. So if someone's left employment, you still need to make sure you treat them with dignity and respect, because if they have been involved with any of these issues, then there's that right remains. I've just added on my notes as well about vicarious liability. So an employee can bring a claim against the employer as vicariously liable for an employee's act. So obviously the employer is just an organisation, and the organisation isn't going to make racist comments or offend someone or do something discriminatory, but the employer as a business is liable for the acts of its employees, unless the employee can say, look, I took all reasonable steps to ensure that didn't happen. The employees themselves, so the managers usually, directors, can be added to a claim. So you might find a claim where someone's alleging discrimination against the manager who said X, Y, and Z, and also the company because they didn't take enough steps to ensure that didn't happen. So that's why employers are always keen on ensuring that there's equality and diversity training. Managers have training on employment rights and things like this, so that A, that it doesn't happen in the first place, and B, that if it does happen, they can say, well, we tried our best to ensure it didn't. There is some additional discrimination rights for disabled people. One of them is the duty to make reasonable adjustments, which is on the employer. And basically, if there is something that puts disabled people at a substantial disadvantage, so that can be physical or not physical. So it could be steps that is putting a disabled person at a disadvantage. They can't attend the workplace because they need a ramp, they're in a wheelchair. Or it could be non-physical, so a policy or criteria. So it might be policy that, working hours are 8 till 4. And disabled person might be, maybe their medication means that they're a bit drowsy in the morning and they can't really work effectively until after 9. So there might be something that this disabled person feels put them at a disadvantage, and provided that the employer is aware that the person is disabled and that they are put at a substantial disadvantage by this aspect, then the employer is under a duty to make reasonable adjustments to try and ameliorate that disadvantage, whatever it might be. It is reasonable adjustments though, so there's been a few cases where I know one where there was a lady who was deaf, and she went for a job and she wanted a sign language interpreter to come with her, and I think the job was in Dubai or something, and the cost of sending an interpreter with her for the length of the contract was far too high to expect an employer to pay that. But costs usually can't justify not implementing an adjustment if that's the only reason. But it depends on the size of the employer. Like a big NHS trust would be expected to spend a lot more money on reasonable adjustments than a small one-man band shop. So the duty is there, and it also applies to job applicants as well, and it applies to service users and sort of hospital trusts and things need to consider this on a regular basis. But it is a massive claim at the moment, and it is often accompanied by a claim for indirect discrimination, or you can get a claim for discrimination arising from disability, and we could probably talk about that all day, but you'll be glad to know that I won't. Yeah, the issue is reasonableness, so the tribunal will look at all the facts and think, how badly did this affect the disabled person? Did they really need it altering? What efforts did the employer make to improve the situation? Did they consider all the alternatives? And that can be an unlimited disability discrimination claim in the tribunal if the employer hadn't considered it properly. So the next little section we're going to look at is family-friendly rights. So there's loads, and the main ones are right to request flexible working, time off for dependents and parental leave, maternity rights, paternity rights, and shared parental leave. So flexible working. Everyone has the right to request flexible working for any reason. So it's not just returning from maternity leave situation. You've got to have, the employer has to have worked there for 6 months, and they can only make one request in 12 months. It's usually a permanent change if it's agreed, but you can negotiate temporary changes if everyone's happy with that. The employee has to make the request in writing, and then the employer has 3 months to consider it. And there's a list in the law of what grounds they can refuse a request, and it has to be under one of those categories. Some of the examples are the burden of additional costs, detrimental impact on quality or performance, or detrimental effect on the ability to meet customer demand. So some of the explanations are so a personal banking company who prided themselves on the personal service. Each customer had their own personal account manager. Didn't agree to some flexible working requests because they said, that's our thing, that our clients can ring up and speak to you between the hours of 9 and 5, Monday to Friday. So that was reasonable in that case, but it will depend on all the circumstances. If an employer has already got 2 staff working part-time and then a third one comes along and asks to work flexibly, they'd have to have a strong reason to deny that request, unless there was substantial difference in roles, that sort of thing. But by no means is the employer obligated to accept the request. They just have to deal with it properly. And if they don't consider it reasonably or apply themselves in the way that the law said that they should, the employee can make a claim, and there is some compensation available, but it's not much. It's capped to 8 weeks pay, but usually we'd find that if there's a situation where a flexible working request had been refused and the employee was really unhappy with it, they normally would bring an indirect discrimination claim and then a claim for refusal of the flexible working request. But the tribunal is more interested in the manner in which the employer dealt with the request rather than their reasons for refusing it. And like I said before, the tribunal doesn't really want to get involved in business decisions. Time off for dependents. So all employees have the right to reasonable time off work. This is unpaid, and it's essentially emergency dependence leave. So if you need to take time off to look after an ill child, or if your childminder has suddenly become unavailable and you need to make other arrangements. But also, interestingly, dependent isn't just children, it's people who have a dependency on you. So it can be people who live in your house, spouse, civil partner, and the statute says anyone who reasonably relies on the employee for that help. So it could even be an elderly neighbour that lives next door that hasn't anyone else to rely on. That right for time off for dependents is only really supposed to be for dealing with that particular emergency, so it's not a long-term thing. If you needed more than a short period of time, there's a right to parental leave. Now, parental leave is different to paternity leave, which is different to shared parental leave. So it's all a bit complicated, but I got it wrong myself. Parental leave is up to 18 weeks leave for each child each year. And that is meant to be for the purpose of caring for a child, but government guidance gives examples of spending more time with children, looking at schools, visiting grandparents. So essentially a parent can apply, they've got to give sufficient notice to the employer, but you can take up to 18 weeks leave each year for that purpose. It's unpaid, and the employee has protections. Yeah? Sorry, I can't hear. I think it's a year, but I don't know. My sources may be incorrect. This lady is saying it's 18 weeks total, 4 weeks a year. Maybe. I'll have to look into it. No, it's possible that you're right and I'm not. This is what my slides tell me. And I did check, but I may not have considered the detail. I'll have to look into that. But it actually doesn't say on the slide per year, does it? It just says up to 18 weeks. It could be, yeah. The employee is subject to is to benefit from some protection if they do take parental leave. So when they return to work, they are supposed to return to the same job or a suitable alternative in certain circumstances. And there's also compensation available for that if the employer doesn't abide by the rules and regulations as it should. Maternity leave, you're probably all familiar with. Employees get time off for antenatal care whilst pregnant, and then they get 52 weeks maternity leave, and then 39 weeks maternity pay. That's statutory maternity pay. Obviously, a lot of employers will provide contractual maternity rights, and they're usually slightly more enhanced than the statutory scheme. The details of the statutory scheme are on the slide there. but essentially, on top of the right to pay and leave, there's also protection for employees when they return from maternity leave, in the way that they are supposed to be able to return to their same job. It depends when they return from maternity leave, but it's the same job or a suitable alternative. If the employee finds themselves in a redundancy situation whilst they are on maternity leave, then they get priority for alternative employment in redundancy cases. So an employer would need to consider the absent employee who's on maternity leave before other employees if there was a redundancy situation. And employees who are on maternity leave can work up to 10 days a year, so keeping in touch days, and that's at a rate of pay that's agreed between the employer and the employee. It's normally normal rate of pay for that period of time. Now, paternity leave, this is the 2 weeks that usually the father takes off after the birth of a child. Doesn't have to be the father, it can be the civil partner, spouse of the mother, someone who expects to have responsibility for the child's upbringing. It's at the same rate as maternity pay. It's either weekly rate or 90% of earnings, whichever is lower. And the similar protections, I mean, it's only a 2-week period, so it's unlikely that someone will come back to a different job after 2 weeks, but they are supposed to be able to return to the same job, and they're also protected from any detriment as a result of taking that leave, which also applies for the parental and maternity leave. Now, there's, that penultimate bullet point says about additional paternity leave. That shouldn't be on there really, because that hasn't existed since 2015. It used to be you could take additional paternity leave, but now it's shared parental leave. So a father or the second parent can take paternity leave, and then if they want to, they can take shared parental leave as an extension of that, which we'll come on to in a bit. For now, we'll just talk about adoption leave, which is very similar to maternity leave and the maternity rights, except for its adoption. So it's the same, 52 weeks leave, 39 weeks pay. With adoption, obviously, there's not a clear mother who's given birth to a child, so the parents have to choose one person to be the primary carer, or the person who will get the maternity benefits, and then the other person would take the role, the traditional role of the father, where they would get the paternity leave. But nowadays, because we've got shared parental leave, it's all very equal, or as equal as people want it to be. I didn't share any of my maternity leave because I didn't want to. But shared parental leave, it's very complicated. I've been to training with a barrister for a couple of hours, and he didn't really understand it himself. But generally, the idea is that, so we'll say the mother, so we'll just assume this is a traditional mother and father situation, where it could be an adoption situation, it could be, 2 mums, 2 dads. But the idea behind shared parental leave, it allows the mum to curtail her maternity leave, so she gets up to a year's maternity leave. If she wants, she can say, I'm going to go back to work after 6 months, and then from 6 months to 12 months, or I'm going to give the following 6 months to my partner, and he's going to take 6 months off. So they could do that. The mum could look after the baby for the first 6 months, and then the dad could look after the baby for the next 6 months, or they could do it at the same time. So you could have mum and dad both off for 6 months together. Or they can chop and change it in whatever way suits. The only thing is that the mum needs to have served a binding notice on the employer to say she's definitely coming back, in order for the dad to have what's left of her maternity leave. So she can't say, oh, I'm probably going to do this, and then change her mind. She needs to serve that notice and say, I'm going to be back at work in September, and then therefore my husband's going to have this much time off. Some people find it works really well. I think when it was introduced, there wasn't really much take up of it. I think it's starting to become a little bit more popular now, but employers and employment lawyers don't like to hear the words shared parental leave, because the regulations and the detail is really, really complicated. But I think people are starting to get to grips with it now. And as with all the other family rights, if anyone's taken shared parental leave, then they have the right to return to the same job or a suitable alternative, and they shouldn't be subjected to any detriment on the basis that they've taken that shared parental leave. Unfair dismissal. This is the bread and butter stuff that we do. I don't know if you know, the Employment Tribunal used to be free to make a claim, and then in 2013 the government brought in fees to bring a claim. It was about between 120 and 240 quid to bring a claim, so it was a big drop in claims. And then I was going to say last year, but I think it was the year before, they got rid of the fees, so now it's free to bring a claim. So there's a bit of an increase in claims because employees think, well, I'll give it a go, it's not going to cost me anything, we'll see where we get. The main claim that we see is unfair dismissal. As I said before, you've got our 2 years continuous service. So if someone's worked for less than 2 years, a lot of employers, provided there's no discrimination or whistleblowing issues, some employers will make decisions to terminate people or make decisions about employment options before 2 years service, because they know that the employee can't bring an unfair dismissal claim. But as we said, it doesn't stop them bringing other claims, so you need to be careful about that. But in where there's a dismissal, in order for it to be fair, so to avoid any court claims, the employer has got to show that there's a potentially fair reason for the dismissal. So they're on the slide: misconduct, capability, redundancy, contravention of a statutory enactment. So that would be if someone's visa expired, then continuing to employ them would break the law. Or if someone was, say, a lorry driver and they lost their driving licence, continuing to employ them in that role would breach the law. So a lot of the time there's terminations in those situations. And some other substantial reason, which is a bit vague, and it's usually an option of last resort, but sometimes it will be where there's a massive personality clash in a department, people don't get on, and the only way to solve it is for someone to be dismissed. Or if someone's on a fixed term contract for a specific project and the funding runs out or the project has ended, then technically speaking that's a dismissal, but it would come under some other substantial reason. The reason for it is the ending of the funding. So you've got to have your reason. The employer's got to be able to show this is the reason why we dismiss the person, and then they've got to show that they were fair in all the circumstances in terms of the way that they handled the dismissal, and also in terms of the decision that was made. So the tribunal will look at the way that they dealt with, say, a disciplinary situation. You need to bring the employee in for a meeting, discuss the issues with them, give them the opportunity to put their side forward, have a hearing that's heard by someone who's independent of the issues, allow the employee opportunity to appeal. These are all set out in the ACAS Code of Practice, which is a statutory guide for employers and employees as to what they should do in disciplinary and grievance situations. And if it did get to an employment tribunal, the tribunal will be looking at whether it was whether the response of the employer was reasonable or within the range of reasonable responses. So they would look at the investigation that the employer carried out, whether that was enough investigation, whether the decision maker had a genuine belief that the person was guilty of misconduct at the time. And even if the employer thinks, say if something's come to light since the dismissal that's put into question the decision of the employer, the tribunal is just interested in, at that time, what information was before the decision maker, and was it reasonable for them to make that decision based on that information. A lot of employees come to us wanting to get their day in court so they can relive all of the issues that have happened in the workplace, but the tribunal doesn't want to look back at everything that's happened. They just want to look back at, on the day of the dismissal, what was the decision that was made and whether that was within the range of reasonable responses. And if it is, then it would be a fair dismissal, provided there's the employer can show a fair reason. So if an employee is successful with unfair dismissal, the compensation is capped. There's a basic award, which is calculated on a standard formula based on how long you've worked somewhere and how old you are. The compensation element of the award is capped at either 86,444 or 1 year's salary, whichever is less. So some people think, oh, I'll bring in an unfair dismissal claim and I'm going to get loads of money, but it can be a lot less than people think. It's also limited. If you are dismissed and then you get a job a couple of months later, the tribunal will usually only look at financial losses. So if you have got another job shortly after the dismissal, then your losses won't be that great. The tribunal doesn't award injury to feelings in unfair dismissal cases. So that's for the discrimination and whistleblowing cases. So the compensation is capped with unfair dismissal, and sometimes compensation will be reduced if there's a failure to mitigate. So, for example, if the employee has been dismissed and they're not bothered to even look for another job, even if the tribunal found that they have been unfairly dismissed, they would say, well, what have you done in the last year? Right, well, we're going to reduce your compensation because you haven't mitigated your losses. There's also a reduction called a Polke reduction, whereby if say the employer didn't do the procedure correctly, so they didn't hold the right meetings or they didn't allow for an appeal, the tribunal would say, well, procedurally it was unfair, but if they had allowed your appeal, you still would have been dismissed anyway. So you've been unfairly dismissed, but we're going to reduce your compensation because of that reason. And sometimes they reduce it to nil. So people have been successful in tribunal but come out with no money on the basis that they would have been sacked anyway, but for that procedural issue. And there's also a deduction or an increase in relation to the ACAS code. So if the employee has failed to follow the code, or if the employer has failed to follow the code, the compensation is either reduced or increased by up to 25%. So essentially, an employees, if they've got an issue, they're supposed to raise a grievance and allow the employer time to look at the grievance. So if the employee didn't raise the grievance, or if the employer didn't look at the grievance, then that's the sort of situation where compensation would be altered. Redundancy. The slides have got the exact wording of the law there for the definition of redundancy, but essentially it's three situations. A business closure, so where someone goes bust, or goes into administration, the entire operation shuts down. There's a workplace closure, so you might have 3 factories, one of them in the northwest closes, but the other factories in the UK continue to operate. Or diminished requirements to do work of a particular kind. So it could be you find that a shop that's now using the automated checkouts will need less checkout staff. So they might make redundancies because there's less requirement for checkout people. So the Employment Tribunal will want to see that someone has been made redundant in a genuine redundancy situation, i.e. it's not a sham, which does occur sometimes where employers use redundancy as a way of trying to get rid of people when there actually isn't a redundancy situation. But the employer just needs to show that there was a need for a redundancy, and then that they dealt with the procedure fairly. And the reason why it's important to know if someone's redundant or not is because if they are redundant, then they're usually entitled to redundancy pay, which can be a lot of money if there's a contractual scheme. There's a statutory redundancy right, which isn't that much money, but some employers, particularly like NHS, will have a massive redundancy payout, particularly if someone's worked there for a long time. So Sometimes employees are really keen to say, oh, I was redundant because I want the money. But an employer will also want to show that it was redundancy, maybe because they want to show that that was a fair reason and that was why someone had to go. Also, it's important, if there's a redundancy situation, there's extra duties on the employer to inform and consult with employees. It's part of the fair process and showing that a dismissal was fair in all the circumstances. But basically, an employer should consult with employees, whether there's 1 or 100. But if there's more than 20, then there's specific statutory provisions that say the employer must elect representatives and must consult with those. It says on the slide there, so consultations must take place with either 30 or 45 days before the first dismissal, depending on how many people are being made redundant. The selection criteria that's used, that's usually part of the consultation process if things are done properly. And employers have to be careful what criteria they use. It's often a minefield, because if you go off experience, then some people say that's age discrimination. So it's meant to be objective criteria. Things like performance, attendance is usually used, but make sure there's no disability-related attendance taken into account. And employees should be shown what the criteria is going to be and given the opportunity to comment on it and say, oh, I don't think that's fair. That shouldn't be taken into account. And then if a decision is made that someone is made redundant, then the employer also has a duty to consider whether there's alternative employment for them, so maybe in another location or a slightly different role. So the employer has to make a reasonable effort to search for something else and offer it if there is something available. If the employee turns that down, then they'll lose their redundancy money. So that's an additional aspect. Finally, yeah. If what, sorry, if has found another job somewhere else? Yeah. Yeah, so if you're employed by a certain person and they say, we don't need you anymore because X, Y, and Z, you're redundant, and then that person that gets a job the following week, they still get the redundancy money, yeah. The final topic is whistleblowing, which, similar to discrimination, is uncapped compensation, and I wrote down a couple. 2009, there was a CEO awarded £1.2 million after a whistleblowing came. A prison officer got £500,000 in 2005. So it can be quite a lot of money. It's also something that employers definitely don't want in the public domain, that they, treated a whistleblower detrimentally, or they dismissed someone because they blew the whistle. It says PIDA there, it's Public Information Disclosure Act. It applies to employees and workers. So it's a wide range of people, not just those who are directly employed by you, but agency staff and some self-employed contractors. And together with the Employment Rights Act, that gives these protection for whistleblowers, and essentially means if they are dismissed because they blow the whistle or raise a protected disclosure is the correct phrase. If they're dismissed because of that, then that'll be automatically unfair dismissal. Or if they're subjected to any sort of detriment because they blew the whistle, then they can bring a claim against the employer for that. So the idea is that everyone is aware of their rights and feels happy. Sorry. A whistle. Yeah. Well, I'm gonna come on to that bit. Yeah. Because there's a few hoops to jump through. But essentially, I forgot where I was at now. Yeah, they shouldn't be dismissed. They shouldn't be subjected to any detriment because they've blown the whistle. this can be brought at any stage of the employment, so on day one, and yeah, there's no cap on the amount of compensation. So whether someone is a whistleblower or whether they qualify for this protection can be quite complicated, and it's been subject to a lot of cases. But essentially, someone needs to make a qualifying disclosure. So an example would be someone who works in a hospital. So obviously this is a big deal in the NHS. Someone in a hospital says to their manager, I think you're breaching health and safety here. Those, the bins haven't been emptied for weeks, and there's needles been left around over there, and someone's going to get hurt, something like that. Or actually, a real life case, there was a consultant who raised issues about the hospital's policy with the bed changes, and said this was in a mental health trust where they were dealing with adolescents, and he raised some issues about the manner in which these adolescents were moved from bed to bed, and that was treated as blowing the whistle, because he was saying, I think the trust is breaching its health and safety obligations. So actually, if you look, the next slide this is the types of relevant failure that are covered by whistleblowing law. So criminal offences, breach of any legal obligation, miscarriages of justice, danger to health and safety of an individual, damage to the environment, deliberate concealing of information about any of the above. So if someone raises any concerns that maybe someone's breaking the law, someone's committed an offence, there's a health and safety issue, maybe staff or patients or clients are at risk because of unsafe working environment, and that's the sort of subject matter. So that's what they've got to raise the issue about, and the way that they raise it, it's got to be conveyance of information, not just an allegation. So you can't just say, it's rubbish here, you're all crap, and I'm going to report you. You've got to say, along the lines of, I think this law has been breached, or this person's in danger, you've done that wrong, or this person's committed an offence, and actually convey some information. Now, it doesn't necessarily have to be true, it's just you've got to have the person's got to have a reasonable belief that it might be true. So it's an conveyance of information about some sort of malpractice. And it used to be the case that it needed to be in good faith, because some people were just bringing claims just to cause havoc. That's not in the law anymore, so it doesn't necessarily have to be in good faith, but it does have to, the person has to have a reasonable belief that it's in the public interest. So there was claims where there was people raising concerns about breach of law because it affected their personal bonus scheme, that this isn't within the legislation. But it needs to be something reasonably affecting the public. It might not be like the whole country or the general public, but it can be a kind of wider range of people than just your own department, if you like. So if someone raises that sort of issue in that way, not just an allegation, conveyance of information, then they might have blown the whistle, but they've got to make sure they blow the whistle to the right person. And the legislation encourages people to tell the employer first. And obviously, if you think the CEO is doing something wrong, you might feel that it's not the right person to go to. Or this is why a lot of employers will have like a freedom to speak up guardian, or an inbox that you can email, or somewhere where you can make an anonymous tip-off. We've had one recently where it was just a typed letter that posted into a director's office, but usually it's meant to be the employer. If you don't think you want to speak to the employer, you can speak to the responsible person. So say if you felt you came across some information that maybe a client was breaking the law or doing something dodgy, maybe you didn't want to tell your employer, you could go and speak to the client or whoever you felt was the person with the ongoing legal responsibility to correct that issue. If you tell them, then that's protected. Or there's certain prescribed people. So doctors will can go to the GMC. You can also go to HMRC if you felt like it was a tax issue, or Director of Serious Fraud Office if you saw some fraudulent activity, or the Financial Conduct Authority if it was something financial. There's a list in the legislation, and a lot of companies have whistleblowing policies to set out all these rights and obligations because they want people to be clear on their rights and to raise issues so that things can be rectified, but also to avoid any claims. There is some times when it's acceptable to make a disclosure to people beyond those that I've mentioned, but it's very rare. So if people go to the press and say, oh, I'm a whistleblower, but they're paid for the article, or they didn't tell the employer before they went to the press, then they're probably not going to get the protection that they could have. One example of where someone went to the press was where there was asbestos at a National Trust site. And I don't know the details why they didn't go to someone at the National Trust first, but that was one of the rare occasions where the tribunal said that was sufficiently serious to allow for someone to go to the press rather than to go to the employer. So, yeah, whistleblowing is a massive issue and can be very costly for an employer, so everyone's really keen to get it right and make sure everyone knows their rights and duties, to promote just a culture of openness and improvement, basically. But it does go wrong, and whistleblowing and discrimination are the favoured claims of employees because of the compensation, and also the most feared ones from employers. So that's it from me and my whistle-stop tour.